Appellate work has many similarities to trial work at the trial court level, obviously, but there are some significant differences. If you are the party, you're representing the party appealing, you're the appellant, you're representing the appellant, you must convince the Court of Appeals that the trial court, the jury, whoever decided the case and however it was decided, made an error that was so significant that there should be a reversal. Something's got to be changed. If you won below, which I've had more experience with, I'm happy to say, but no one has an unblemished record that way, then you want to convince the Court of Appeals that it was done correctly below. Nothing should be disturbed here. So that's the goal. You need to understand what the standards are for the kind of appeal that you're pursuing and keep those standards in mind. I'm not going to go into that. It gets technical and there's really no need to do that here. But it's very important to keep that in mind. When it comes to brief writing, one wants to think through very clearly after having studied the record below, and when I say below, I mean at trial. What happened? Know everything that happened. Know the trial record cold. And then begin to formulate what are the issues that I can raise on appeal that have real meat to them, that have power and force to them, that are going to get the attention of the Court of Appeals and hopefully persuade them to reverse. Or I've studied the record. I'm representing the appellee, the party that won, and there's nothing in this record that would support a reversal or disturbing in any way the decision that was made below. So that's what I'm trying to do. I'm studying the record. I know it cold. I think about what the issues are that are worth raising, and then I start writing. The brief, of course, has to be clear, succinct, without being too brief, logical, persuasive, and completely supported. There is no statement of law that's made that isn't supported by cases that really do mean what you say they mean. There are quotes from the record that are not cherry-picked, taken out of context. They really do represent fairly what the point is that you're trying to draw out, so that when the clerks, the appellate clerks who study the record, look at the representations that have been made in the brief, and they are representations, they can say, this brief is reliable, this brief is trustworthy, this brief deserves great weight, and it is persuasive. When it comes to oral argument, I'm reminded of a dinner that I attended, I sat next to Justice Scalia. I had known him because I'm a trustee of the Supreme Court Historical Society, and he and I had done a number of events together. And somebody else at the table, he was sitting directly to my left, somebody else at the table asked him about the importance of oral argument on appeal, because lawyers always wonder if it really makes any difference. And Scalia sat back in his chair thoughtfully, and he was the kind of person who usually answered questions with remarkable speed. And he said, after thinking about it a minute, they're much more important than you think. And then he said, what makes a great oral argument great is a lawyer who has understood the case and the issue so well that he or she knows what's important and what to argue and what not to argue, because it's peripheral. It doesn't matter. It's too weak. That lawyer understands the case, and that lawyer has a better chance of making points and changing minds or reinforcing viewpoints that are favorable already to that lawyer's position, just because he or she is not wasting time on peripheral things that don't matter, is not yielding to insecurities that so many lawyers have. I've got to raise everything. And Justice Scalia was saying, you shouldn't raise everything. You should raise the things that really matter. And you should understand the case that well that you really know what matters and what doesn't. In oral argument, you must never be afraid of what we refer to as a hot bench. That's panel members, judges or justices, if we're talking about the Supreme Court, who are peppering you with questions. That sounds intimidating. It sounds horrible. It's a great opportunity. The judges are telling you what's bothering them. You're getting a chance to change minds, or, as I said earlier, to reinforce a viewpoint that some of them already have that are favorable to you. Don't fear questions. Seize them, be responsive to them, be clear, be succinct, answer them. And also bear in mind that the time limits are excruciatingly short. Most cases in the United States Supreme Court only allow 30 minutes to argue. 30 minutes. In most federal and state appellate courts, it's no more than 15 minutes. And when the red light goes on, when you're at the lectern, that means you sit down. In some circuits, in some United States courts of appeal, if you're in mid-sentence, you're going to be told to stop. So you have to be mindful of the time. That's why everything you say matters. And sometimes you have to be prepared for the worst kinds of surprises. I was arguing a trademark appeal that we had won below, and we won it in the Court of Appeals as well. The first question that was asked by the first judge in the appellate court, someone I knew very, very well and like a lot, his question to me caused me to realize in horror that he didn't understand the first thing about what a trademark was. And this was a trademark case. And I said to myself in a flash, my God, I've got, maybe I can allocate 5 minutes out of my 15, maybe 6 minutes, no more than that, to trying to tell him what a trademark is and how that trademark relates to the case that is being argued that day. It all worked out, but the point is, you can't anticipate that something like that will happen. Things like that happen. So you have to be emotionally flexible, you have to be intellectually flexible, and you should structure your notes such that they're not in any way a script. Not at all. You can move from one point to another point to another point because you don't know what's coming at you. That's how I approach appeals.